Hey, welcome back. Part 2 of Chapter 8. I'm going to finish up talking a little bit more about different risk transfer types associated with contracts. Right now I'm going to flip over to go back to where we left off. We were basically just finished up talking about named insured endorsements, additional insured endorsements. Now I wanted to talk a little bit more about contractual risk by type of transaction. So as you're entering a risk transfer scenario, here's some examples of where you might use those risk transfer options in different ways, different parts of your business. First one would be a construction contract. So you're getting ready to build something. Let's assume you're building a new building. You're going to hire a contractor to do that. It's the most common thing that we go under. We hire them to either build a pipeline, or we hire them to build a building, whatever it might be. You have a contract in place, and this helps transfer some of those uncertainties. Neither party may be aware of the mutual promise to indemnify each other. So, it's always important to know as a risk manager what kind of contracts are going on in a company. We'll talk more about this at the end of the chapter. You may not be directly involved in the past, or maybe you haven't to this point. You need to get yourself inserted in this so that you have an opportunity to review any contract associated for construction or service, or any purchase order contract that might be put out there, as well as leases. If you're not included, you don't get that opportunity to insert what needs to occur in those transactions to make sure that you're protected as a company. There are definite opportunities to create conflicts and interpretation conflicts, because you're not really sure who's transferring and the indemnification, especially if there's multiple parties that are transferring back and forth. So the legal team at your organization, as well as your risk management team and key managers, should be able to recognize common forms of contractual risk transfers that are out there, like these types of contracts that we're talking about here. And this is just a list of the most common ones. First one being construction contracts. As I said, building contractors work that creates any loss exposure for you. They're primarily liability exposure for the owner of the building under construction. So if they build it incorrectly, someone gets hurt while they're building it, those are all liabilities that would increase as a result of their work. You want to make sure you're protected. Their work or activities can harm not only their own, but can also hurt subcontractor employees, as well as anybody who's passing by or a member of the community. Could be an owner of an adjoining property. So there's a lot of opportunities for liability there. The building owner or landowner is ultimately liable for any harm. So even though you may have caused it as the contractor, the person who's hiring you still ultimately has the liability for anything that's done to the public. So as an example, if someone walks by and they know you're the owner, the first thing you do is look up who owns that piece of property that I got harmed on. They don't care who the contractor or subcontractor is. They're going to most likely sue you. Not only are they going to sue you for any damages, they may sue you for any breach of permitting, building permits, as well as building codes, by decisions that are being made by your contractor. So you better ensure that if you're hiring a competent contractor, they know what the building codes are, that they're performing or following building permits as closely as they should. Having in their construction contract language, it would protect you against such liability. So the landowner normally would require the contractor to hold them harmless from certain construction-related claims, which we're going to talk about hold harmless agreements a little bit closer going forward. Caution though, you need to closely review any construction contract for the scope and the potential damage, what could occur in the building. So anytime the building project, anytime I get a contract that comes across my desk in our department, we typically go back to the project manager on the front line to find out what are they doing, what could go wrong, where would the potential biggest risks be impacting the business, so that you can appropriately build those into the contract language. Service and maintenance contracts. So anytime you have, for example, I'll give you our best example would be power plant. A lot of times we'll hire service contractors, people, large corporations that come in to Sheba that put together the power unit. They know how to maintain that combustion unit. they're going to come in and do the work. So these type of contracts are purchased on a continuing basis. Unlike a construction contract that has a beginning and end and the building's built, it's over, a construction maintenance contract goes on and on forever, depending on how often you bid it. So the providers of this maintenance would typically agree to a hold harmless agreement that is general and broad, meaning the contractor usually agrees to hold the customer who's hiring them harmless from any property, liability, and other losses, except for revenue losses. And then the customer may suffer because of the contractor's error, and takes responsibility for claims arising solely from the customer's negligence. So not only will they accept their own negligence, they may actually be willing to accept the negligence of their customer as well. It's kind of rare, and what we found, or what I found in some of our larger maintenance contracts, we don't have very much negotiating power. So we typically watch them typically don't accept a lot of their own liability. And unfortunately, if we want to do business with them, then, and we have very few people who can do the work, we have to accept their terms and conditions. Purchase orders. So this is how we typically pay for every other type of work, whether it be buying a product or implementing a service contract. And our department in risk management, we typically review every purchase order for every service and for every product we're buying, and we implement some kind of contractual review of what we'd expect to see our contractors to have in terms of liability insurance, property insurance, auto liability insurance, and make sure that's in there. So with a purchase order, you can face liability from products that you're buying. So, you know, a lot of people don't think of this. If you're a retailer, let's say you're O'Reilly Auto Parts and you're buying tires and you're buying auto parts that you're going to sell to customers, even if you didn't build that product, you still have a certain level of product's liability because the end user knows they got it from you, and if it fails, they're going to sue you. You, in turn, could sue the manufacturer, but what I want to point out is that any claim that arises from a product that you are selling, whether you are the person who created the raw material, provided the raw materials, any components, or any supplies, those ultimately still fall as a liability upon your company. Any organization in the distribution chain has the right to ask any other party in that chain to provide them with protection. So again, if O'Reilly is going to accept responsibility or liability for a claim, they're going to be interested in going back against the party who built that part or that product. POs and purchase orders may require immediate supplier or vendor to hold the purchaser harmless through contractual provisions. So if I'm City Utilities and I'm buying a product, I may expect my vendor to hold me harmless for any damage that a product may cause, and then I know that I have an automatic out if something goes wrong with that product. The purchase order, hold harmless, may contain exclusions and conditions. Usually, you're exempt from claims due to the purchaser's sole negligence. So if I sold a product and I sold it for the wrong purpose, that is typically my own sole negligence, or I misled the buyer of what it could be used for. That would be mine. That would not be able to be covered in the hold harmless agreement. Notification and cooperation. So if I'm going to require them to hold me harmless, I need to cooperate with that vendor and allow them to manage the claims fully, cooperate with them on any information, notifying them in a timely manner when something comes up associated with that product. So you actually, just like with an insurance company, have to be fully cooperative throughout the process. Many hold harmless also protect the purchaser. So when a purchaser has the bargaining power, you know, I'm the company buying it, then you're going to obtain the vendor's promise to indemnify or protect you. It helps with the sale of the material, and they're willing to give it because if they know they give you that warranty or promise that they'll hold you harmless for something they're selling you, it's going to give them more leverage in the transaction. However, I would caution people to use some hesitance here. Multiple agreements can cause confusion. So if different parties are signing agreements holding each other harmless, sometimes it's really hard to figure out who's actually holding who's harmless. Like, I'm going to sign one that holds you harmless, and you're going to sign one that holds me harmless. There's a lot of confusion, especially if it goes across multiple different parties of the transaction. Loss exposure should be assumed by those most qualified to control them. So if you're the person building the product or the person building the building, you're the most qualified to control any risk. And those are where we try to place the loss exposure responsibility as closest to those that are best qualified to manage them. Leasing premises. So we just talked about how lease can be a risk control measure. It also can be a risk financing option. So a lease allows the lessee to enjoy the property. You're leasing it. The lessee's leasing it, the property. They get to enjoy that property without being subject to many of the loss exposures that would be inherent in ownership. The lessor, the person who owns it, can attempt to use the lease to transfer some of its financial burden through transferring some of those losses to the lessee. So they're going to try to give the risk financing side back to you as the lessee. So you're using that tool, a lease, as a risk transfer option. They, on the other hand, are using the lease as a risk financing transfer. So you're both using it to your advantage. So in order for them to utilize this as a risk financing transfer, that means they need to put language in the lease that holds you obligated to follow through on taking on some of the responsibility. So many lease agreements are written to favor the lessor, the person who owns the property. The lessees often have to accept those without revision, especially if you're the small guy and you're signing a lease for rental of apartment. You typically are not in a position where you can negotiate that. And if you're a small contract or small business, it's really hard to negotiate those out. Courts typically interpret leases with the assumption that the parties have equal bargaining power. This is especially true when you have business type leases. Not always 100% accurate, but that's what courts typically that's how they view them. Attempts to transfer risks to a lessee's work comp insurer. So if you're trying to push back on the lessee as the person owning the property, the person who's leasing it, and you want to hold their employees responsible or any of the liabilities to their general liability insurer, it's highly likely going to be challenged by the courts, by the injured parties. So you can try to put in clauses that transfer some of the risk back to the lessee, but it may be challenged ultimately. So there's something to be aware of. Equipment leases. So an organization can lease equipment usually promising to return the equipment to its original operating condition, assuming that you keep it for 5 years. It's going to be 5 years older and it's worth less, but there are certain exceptions. The promise protects the lessor, the person leasing the equipment, against loss of the equipment. So, which is outside their direct control during the period of lease. So they can't control it, but if you damage the equipment, they can force you to pay for some of those damages. That's that risk financing transfer. The promise is not too burdensome for the lessee, typically, because the lessee assumes no financial responsibility for the liability claims, but they are accepting the liability for the property value of the equipment that they're leasing. And the lessee is also responsible only for the property value, like I said, of the equipment, not for any revenues that you lose, potentially because the equipment that you were returning to them is now damaged and it can't be used for a future rental. So really all you're promising is the value of the equipment that you would have either bought on your own with your own money, but instead you've chosen to lease it and you can give it back to them and pay them for what the fair value of that equipment would be. Some equipment leases obligate the lessee, person leasing it, to hold the lessor, the equipment owner, harmless for any liability associated with the equipment. So if one of your employees gets hurt with the equipment and they file a claim against you, most likely the lessor is going to say, I gave you the equipment and you need to operate it safely. If you fail to do that, that liability is on you. Lessee might be required to maintain insurance while they're keeping the equipment. So even though they are leasing it, they don't own it, there may be some kind of rental equipment policy that they want in place that helps reduce the liability, or they need to show proof of a general liability policy for any of their activities that they're doing in their business. Bailment. This is, we've done this in previous classes, but bailment is a business transaction that involves personal property that you put in the custody of another party. They're either repairing it, safekeeping it for you, or they're transporting it for you. So you're taking someone else's property and you're either taking care of it for them for a period of time, or you're moving it for them, or you're helping repair it. This is temporary possession by one party, which we'll call the bailee. the party that's got temporary possession to repair it or to move it, for someone else was called the bailor for a specific purpose that we've just previously mentioned. So under common law, the bailee, the person who's taking possession of the piece of property, they have to exercise ordinary care for the safety of their property, exclusive of the damage caused by acts of God or normal wear and tear. So those type of damages typically are excused. There are two primary bailment types. Make sure you know these. First one is a mutual benefit bailment. This is an arrangement where the bailor, the person who is giving up their property, pays the bailee who's taking care of it for them for the work or service that they're doing. So I'm paying you to repair my car. I'm paying you as a transportation company to move my equipment. Those are things that I'm actually have an arrangement where I'm paying you for the care of my property, and both parties are expected to benefit from the transaction. The bailor gets the benefit of something being transported to them or being fixed, and the bailee gets a fund or gets monies for their services. So there's a mutual benefit. A gratuitous bailment is an arrangement where the bailee, that holding possession of your equipment or your property, receives no compensation whatsoever, and they owe you a lesser degree of care. So a gratuitous, meaning they're given to you free of charge. Maybe they've let you park your vehicle on their piece of property and they don't expect any payment in return. It's a gratuitous bailment. However, even though it's on their property and they have it behind a locked gate, if something happens to your vehicle or your property while it's behind that gate, they don't owe you as much because you're not paying for it, but they do have a certain degree of care. Some other special bailment agreement, which don't necessarily need to know for the exam, but I'll mention a common carrier. So let's say you are a trucking company. There's a bailment agreement that involves the transport of goods in accordance with a certain schedule or fee schedule that they have in place. The degree of care then exceeds that of a mutual benefit bailee. So the fact that you actually have a schedule and a fee that you would need to follow, there's a higher level of responsibility with that common carrier bailment. Bailees can attempt to limit their liability, either to the property's value or seek only, bailers can seek to increase the bailee's liability. So, a lot of times the transporters like to say, I'm only going to carry you or provide value up to the weight of the material I'm shipping, which I think I've mentioned this in another class. So if I go ahead and tell you I need you to move a 10,000 pound piece of equipment that's worth $10 million and you try to limit to a weight value, it doesn't mean a whole lot because you could have something that weighs the same that has a lot less value. So you as the bailor and the owner of the property, you really want to try to increase it to what's a fair marketable value. Either can have a business reason for assuming liability. Maybe the bailor is willing to do it because they want your business in the future, or you want to increase, you actually are giving up more of the rights and responsibility because, you want them to do something else for you. So a lot of times you'll take on more than what common law requires you to do, just because there's some benefit, other business benefit in it for you. Sale and supply contracts. So these typically are set up to offer opportunities to transfer risk between a buyer and a seller. The transfer usually favors one party with the greatest bargaining power or negotiating power, no surprise. So contracts are similar to insurance if they go beyond guaranteeing the quality of the goods or liability of the supplier's performance. So typically they do this to attract customers. They're willing to do more, take on more responsibility than they're required to by law because they want to gain your business. The time when ownership changes is very important. So the most common sale and supply contract clauses out there, you guys have had these in previous business classes, I know. First is when the shipping condition involves when does ownership pass between the buyer and the seller. So free on board destination, if you guys don't remember, is that condition where ownership does not pass from the seller to the buyer until the goods are received at the buyer's premises. So it's free on board the destination, meaning it's free to me until it gets to my destination, meaning anything that happens from their shipping dock to my gate or my dock means that it's on them. Free on board shipping point means it transfers to me from the point of origin. So that shipping condition, ownership passes to the buyer as soon as the carrier picks it up. Well, there's a lot more risk there. If you get a $10 million piece of equipment that's being shipped and it's yours and you own it from the time it's getting picked up, what if it gets dropped? What if it gets damaged in transport? That's on you. So you need to make sure you have protection there. So it's always better if you're the buyer to have free on board destination. And conversely, it's better if you're the shipper and you're free on board destination point of origin. So you kind of want to negotiate. If you're better negotiation skills, you're probably going to be pushing for that. If you do not have the better arrangement, you definitely want to make sure you have protection from the transporter side. Cost, insurance, and freight is another selling term where price includes not only the cost of the equipment, but the insurance and the freight until the goods reach your destination. So that CIF is basically covering everything, the cost, insurance, and freight aspects of that transaction. And an installment or conditional sales contract, this is where the seller reserves ownership rights until the buyer meets all their conditional or contractual conditions. So until you make that final installment payment on that installment contract agreement, essentially the seller still has ownership rights. If you fail to make those last payments, it reverts back to them. Real common contract that's put in place for those type of arrangements. The last things we're going to cover on is just what common law requires you to have in a contractual risk transfer. So typically you're responsible for yourself and no one else. That's a common law. We all know that. If you do something wrong, it should be on you. If the other person does something wrong, it should be on them. And anything in between where you're jointly responsible, you probably should share in it. Well, let's talk about different arrangements where some parties actually take on more than what common law requires them to take on. For easy way of talking about this, contracting parties throughout these examples are noted. O stands for building owner and C stands for contractor or general contractor. So we're going to talk through some examples. The first one being limited form, contractual risk transfer, and intermediate and broad. So in the first one, limited form, this is where the contractor or party C holds the owner harmless for responsibility for losses that are completely their own fault. So the contractor says, I'll take care of anything I'm at fault for, and I will not hold you responsible. I'll hold you harmless for anything that's my fault. That completely makes sense. That's fair. That one party or the transferor transfers the responsibility for fault to the other party. So they're basically saying, contractor, remember, the owner could be ultimately responsible for anything that happens, even if it's not their fault, because someone could sue them. But in the limited form, the contractor is willing to say, I will hold you harmless for anything that's my fault. An example, like I said, is an agreement to hold the owner harmless for harm caused by their own negligence. Without this agreement, the owner would be held liable or responsible under that vicarious liability in common law, meaning it's ultimately my piece of property and someone got harmed on it, even though it was your fault. Why? Because one party can be held liable for the actions of the subordinate because of their relationship that exists between the parties. Intermediate's a little bit more gray. So you have two or more organizations working together to fulfill a contract. They may jointly be responsible. Maybe it's a little bit your fault, a little bit my fault because I didn't warn or put up warning signs, whatever. We have multiple contractors on site and not all of it can be pointed to one party. Or they may be joined as defendants in a civil suit, charging them both at fault for tort or breach of contract. So under common law, both parties would be held jointly responsible for harm, meaning they both have some piece of that responsibility financially. In the intermediate form, the one contracting party transfers their common law responsibility for being jointly responsible to the other party. So let's talk about this. The contractor, the one party, would be accepting the responsibility from the transferee. So transferor is the party the owner, They'd be transferring the responsibility for their claims that arise from joint fault to the other party or the contractor. And the contractor is willing to accept that. That's not always the case, but let's say they are willing to do that because they want to get the contract, that would be considered an immediate form. Hold harmless under this transfers sole fault of the transferee as well as the joint fault of both parties. That's what an intermediate form is. Finally, the broad form. This is the one that's probably the most hard to accept by courts, but let's talk about it. So each of these forms gets progressively improves the position of the transferor or owner by giving more and more financial consequence to the transferee, that contractor that's willing to take on. So the broad form, it not only accepts their own liability or responsibility and the joint liability, but it also is willing to accept anything that's your fault as the owner. So they're accepting all financial consequences regardless of fault. Many state courts refuse to enforce this type of agreement because basically you're holding that indemnification for acts that the transferor or owner should have responsibility. That's not appropriate because they had responsibility or negligence. They should pay for their own negligence. They shouldn't transfer that responsibility to some other party that had nothing to do with it. Now, obviously someone with higher negotiating power could get that, but doesn't necessarily mean it'll be upheld in court. The provision seeks to make the contractor financially responsible for all bodily injury, property damage, and claims against the owner. That's what the broad form does. So you are trying to make your contractor fully responsible for everything, even if it is solely your own fault or your employee's fault. Transferee under this agreement in effect becomes the insurer. By them willing to take on everything, they're essentially saying, I'm going to insure you for any loss, even if I have no fault in that particular incident, which is a little bit difficult to accept, like I said, in some courts, but that's the broadest. It accepts everything. So one of the last things I want to talk about is these statutes. So a lot of these statutes typically prohibit some of these egregious or unconscionable type agreements where they don't make sense. An all-inclusive statute, that would be where the statute does not it entirely prohibits the transfer of risk. So they're saying, you know what, you can't transfer any risk that's yours to some other party. And some statutes prohibit virtually all hold harmless agreements, regardless of the type of wrongdoing, even if it's their fault or partially their fault. They basically say, I do not uphold all hold harmless agreements. Very narrow in its application. It typically only applies to architects, engineers, surveyors, and anything of their associates that are involved. Any other hold harmless that involve business owners or contractors, any subs, would typically be presumed to be valid. So this all-inclusive is very strict to a certain subset of contractors or parties. Secondary type of statutes would be statutes that prohibit particular wording. So some statutes prohibit anything that narrowly defines a class of hold harmless agreement, such as transfer losses resulting from the person transferring their own negligence. Let's say, you know what, we're not going to accept that, but we'll accept everything else. It prevents use of prohibited words and phrases and wording that would limit bidding. So some statutes just are kind of like, we don't accept these type of transfers. And then the last is statutes placing requirements on agreements. So some of those statutes must comply with certain, in order to have an agreement, a hold harmless agreement, it has to comply with certain requirements in order to include that hold harmless agreement and ensure that it's legally enforceable. So if you're going to manage a contractual risk transfer, there's a lot of things, as a risk manager, you should be aware of the legal restrictions that are out there that govern the use of contractual risk transfer, and you should be developing a risk management program to manage such transfers. Consistency of your program is the most important. You have clearly written and enforceable and disseminated organizational policies on contracts, meaning your purchasing department and any of your managers that are implementing service contracts should be aware of what the standard contractual requirements are for your business and trying to enforce them. Using a the use of negotiation of contractual transfer, basically you're trying to reduce the company's liability, their exposures, as well as their costs. So whatever you're trying to implement should be to the best interest of the company in reducing costs. Contract that is not enforceable if it's unconscionable or in violation of public policy or statute. So those are very difficult to defend in court, and I want you guys to make sure you know this, that contracts are almost never enforceable if they're unconscionable or are in violation of public policy. You should always understand the nature and extent of the risk being transferred. As I mentioned before, as a risk manager, I may not understand what the contract really is involved with doing. What am I trying to transfer? What's involved? What could go wrong? I must always have to interview or find out more from the first party that's involved in the transfer and contract, find out what can go wrong since it's not in my wheelhouse. And the more I know, the more I can make decisions on what kind of insurance should be required, what kind of language should be stressed in the contract. Also, we always make sure that a legal or attorneys involved in reviewing any of the legal obligations. How enforceable will this contract be? Would it stand up in a court of law if it was challenged? So that legal enforceability is really important. You don't want to do something that would not be fair to the other party, that would be unconscionable and would be in violation of statute. You don't want to try to hold those up, because most likely if they see a trend in the court that you're trying to push forward these unfair type of contracts, you're probably not going to stand very long on your policy. It's also important to review dividing lines of responsibility. So how easily can you enforce them? You know, it's really difficult to transfer the negligence of your own employees and things that you have sole control over. So you need to be really careful of those. Determining who best can manage the loss exposure and pay for them. That's another really important thing to know. You know, if you know the contractor is better suited to control the risk, then you should make them responsible for managing the risk control. If you are directly involved or you have someone involved, maybe you feel like you could better manage it, then it's real important to place it there, or with a subcontractor that could be involved. You need to make sure you have a consistent transfer strategy. A defensive approach to a strategy, risk transfer strategy, would be that you're requiring organizations, you want to avoid becoming a transferee, meaning you don't want to be the one that the risk is transferred to. So that might be your defensive strategy. If you're doing an offensive strategy, that would be taking advantage of the other organization by wielding your economic power to transfer risk to them. So if you want to be defensive by keeping from being a transferee, or you want to try to push those risks on someone else, that's more of an offensive strategy. You want to be really cautious about being too aggressive in your strategy, like I said, because courts will look at this suspiciously. You want to implement something that's more balanced and productive for both parties. So regardless of your size, an organization should have controls in place to better manage their strategies, these administrative controls that we're talking about, making sure that you have good auditing procedures in place, good record keeping, making sure that all contracts can be found easily. A lot of companies will put an RMIS system in place. That's a risk management information system. Having all the contracts in one place where you can review them and make sure that all of the clauses can be found easily, and when there's a disagreement, you can find them more quickly. And like I said, having better control measures. So every time I look at a contract, or I have my team look at a contract, we're basically saying, what's the size of the risk or hazard that we're dealing with? What risk can we accept? Which ones are we willing to, can we not accept, or we need to transfer in some way? Maybe they need to be insured, or we need to ask the third party to insure them. But either way, we need to look at ways to minimize the risk. And there may be some certain insurance that's available. So again, I always look for proof of insurance. If there's a type of insurance that can be purchased, if not by yourself and your company, by the third party contractor, you're going to be asking them to buy it and showing proof that they have it. Those are things that you should be doing as a good risk manager. So finally, what's the fundamental guidelines of contractual risk transfer? First of all, developing a consistent risk transfer strategy. If your goal is to make your contractors responsible for things that they are closely managing and making them responsible for their own damages, those are really good transfer strategies. You want to also negotiate as best you can, but you don't want to push too much risk their way. That's not fair. You want to ensure that whoever you're utilizing, whether that be, a third-party contractor or subcontractor, that indemnitor can fulfill its legal obligation financially through insurance. Don't rely solely on their promise because it doesn't guarantee payment. Showing that they have proof of insurance, I always ask for that certificate of insurance requiring that proof before the contract even begins. So saying they're going to have $2 million in coverage with a $10 million umbrella is great, but if they don't show me they have it, it does me no good. And I also want to know when it expires, and I want to make sure that it's renewed on a timely basis while the contract's in place. Make sure you're being named as an additional insured. Again, it's really important. It's free coverage. You get notice if they fail to keep the coverage, and we always ask for that, and we almost always get it, especially being a larger governmental contractor. Avoid being too severe, because again, that could be considered invalid if unconscionable or contrary to public policy. Be aware of any imbalance in bargaining power. You don't want to take advantage, as well as you don't want to be taken advantage of. Be really cautious about any ambiguity. So if a contract doesn't have clear language about, what about your own negligence or intentional wrongdoing on the part of the other party, you want to make sure that anything that would be viewed unfavorably by the courts would be not viewed against you. And you want to become more active in any legislation that prevents that imbalance of power. So any statutes which limit contractual indemnification, you don't want to see those. You want to make sure people are being held responsible for what they should be, as well as not taking advantage of the other parties that they should be being held responsible for some things that they have control over. And that is everything I have for contractual risk transfer. In the very near future, I'll be setting up a review session with all of you. Hopefully you guys will have an opportunity to watch both videos, and then we can get back together and start reviewing for our 4th exam. And after this, we only have one more exam, which will be our final. So we're coming into the home stretch. Please reach out to me if you have any questions, if you're not sure how to move forward getting ready for the exam and how to prepare, or if you're unsure about what is expected of you for the remainder of the semester, please reach out to me either via email or text, and I'll work with you. Thank you very much. Hope you have a great rest of your week. Talk to you soon.